Good morning. Really excited about the information that Nina just presented. I mentioned as I was walking down that I think she needs to stay in this position now because if there's going to be a December launch, right? So maybe she'll come back for a repeat performance. I'm sure they'll let you draft the annual report if you'd like to do so at the end of the year. So I'm Caroline Cirolo. I'm a partner with Castellanos and Fink in Washington, D.C. I am super excited to host and moderate this panel. Let me start by saying thank you to Nina and the Office of the National Taxpayer Advocate. We are thrilled to be invited and have the opportunity to present here today. Also want to thank the American College of Tax Counsel and tax analysts for sponsoring. The food is great at this conference. I don't know if anybody's noticed, but the ABA has some, explaining to do. Take some notes. And thank you, all of you, for attending this morning and listening in. Our topic is whistleblowers, protection and privacy. We'll spend about the next 90 minutes exploring the role of whistleblowers in tax administration and in our respective jurisdictions. Let me start by introducing our esteemed panelists. I've been practicing names, so forgive me if I mispronounce. So, okay. So we have Karika Fritz and Monte Bota. Monray, oh my God, right off the bat. Monray Bota from the University of Pretoria in South Africa. Wei Shui from and Sherry Wang, who may not be in the audience yet, but she helped, from PA Allard School of Law, University of British Columbia in Canada. Ylva Larson and Eleanor Christofferson. Close, from Årbro University in Sweden, and Dennis Ventry, this one I can do, UC Davis School of Law in California, US. Our plan is to explain the current landscape facing whistleblowers in the respective jurisdictions, including the history of the whistleblower provisions, current statutory and regulatory framework, the whistleblower protections, confidentiality and role of the press in these cases, and any pending legislation and guidance. And there is some ripped out of the headline stuff coming, so excited for the presentation. We'll conclude with some Q&A for the panelists. And with that said, we welcome questions throughout. If you have a burning question you want to ask, just stand up, we'll get you the mic and throw it out there. So let's begin with Dennis and the United States. I'll do this quickly since I was supposed to do it while I was talking. There you go. There you go. Thanks.
Well, like everybody else, I'm delighted to be here and truly inspired to see all the work being done around the world in the furtherance of taxpayer rights. Moreover, it's a real honor to participate in an event that reflects the galvanizing force of one of our longest serving and most treasured public servants. We owe you everything here in this country with respect to taxpayer rights, and so thank you. But let's talk about ratting out tax sheets, which is much more interesting. So in the United States, we have two models, let's say, when it comes to whistleblower statutes. We have an administrative model, we have a litigation model. The administrative model, the IRS whistleblower program reflects the administrative model, as does the Securities and Exchange Commission whistleblower program. That is, there's an animating statute, and then the agency associated with carrying out the responsibilities of the statute then promulgate regulations. In both cases, that is both with respect to the IRS program and the SEC program, the regulations are extensive. Then you have a litigation model. And the litigation model is based on a series of false claims acts there's a federal false claims act, and then there are 28 state false claims acts, and also one in the District of Columbia. So we'll work through this sort of administrative model first, and then litigation model second. So the IRS whistleblower program, in one form or another, has been around since 1867. It followed by 4 years the False Claims Act, which was enacted in 1863. Both of those, the Federal False Claims Act, both of those statutes had everything to do with false claims being made against the U.S. government, the Northern government, and took place during the Civil War. Oops. Have I been fast forwarding while I've been standing up here?
No, it may be on automatic.
There we go. Great. Sorry. So the language in the original Internal Revenue Law enacted in 1867 permitted payments for, quote, detecting and bringing to trial and punishment persons guilty of violating the Internal Revenue Laws or conniving of the same. This exact same language, it hasn't been changed. It's reflected in 7623A. In 2006, which, I mean, there's a huge period of time between 1867 and 2006. For the most, and I'm sort of, I actually have a PhD in history, but I'm a total fraud as an historian now. I can tell you other things that happened during that period of time. Sorry, let me just keep going back. This is going to be fun for all of us. But for the most part, the statute was underutilized for that period. The administration of it was spread throughout the country. And so in 2006, Congress breathed life into the statute. They enacted 7623B, which applies to quote unquote mere underpayments of tax. There's a strict liability standard there, so you don't have to prove fraud or any kind of mens rea. And the idea was to almost automate the awards associated with the program. So if the whistleblower provided unique information and original information pertaining to underpayments of tax, and that information resulted in the collection of unpaid taxes and penalties and interest, et cetera, collected proceeds, as the statute calls it, then that would result in an award somewhere between 10 and 30%. Of whatever the collected proceeds were. There is this structure that is reflected also in some of the state false claims acts, but where you have this threshold. And so long as the taxpayer, just to even get in the door, you have to be submitting information for taxpayers that have gross income exceeding $200,000 and then underpayments of tax exceeding $2 million. So the idea was to make this sort of the big dollar kind of underpayments. You can still use 7623A for the lower amounts. One of the hiccups over the years was the definition of, or challenges was the definition of collected proceeds. And in 2018, Congress added another provision under 7623, which expanded the definition of collected proceeds to move beyond just violations of Title 26, which is our Internal Revenue Law, Internal Revenue Code title, to include things like fines, criminal fines, civil forfeitures, and FBAR penalties. That's been an improvement as far as the tax whistleblower bar is concerned. It's been a big headache for the whistleblower office because they've had to go back through and check the 29,000 plus claims that are currently on file to see if, in fact, they reflect possible collected proceeds that are now under the expanded definition. In terms of how it works in the United States, like submission all the way to paying the awards, here we go again. You have the IRS Whistleblower Office, which was also created in 2006. It processes, it has intake of the claims, it processes the claims, it disseminates the claims to the various IRS investigative units. It then evaluates the investigations of those units and the tax deficiencies, if any, that the investigation produces, and then also the proposed award determinations, conducts a final review of both the deficiencies and the awards, allows time, and these last two elements are important for purposes of sort of how long this process takes, allows time for taxpayers to appeal and litigate their deficiencies, and then also allows time for the whistleblowers to appeal and litigate their award determinations. And so this process takes forever, as you see at the bottom. On average, it's at least 8 years from submission of a claim to actually getting paid, to somebody getting paid. And in 2018, the awards paid in 2018, the average amount of time there was over 9 years. One last slide on the administrative model. Since 2007, I mean, by most accounts, the changes in 2006 have been incredibly beneficial. It depends on who you talk to. Any program can be improved upon, but for the dollar amounts are kind of staggering. The IRS has paid over $800 million in awards since 2011. 1.4 billion. Collected proceeds of $5 billion. So then, in terms of the yield, the ratio for awards to collected proceeds, 16.2%. It's comparable to the SEC whistleblower program in terms of yield. In fiscal year 2018, they paid a record $300+ million in awards on collected proceeds of $1.45 billion. And you see an uptick in the yield that starts to reflect the new the collected proceeds expansion a little bit. In 2018, you also saw over 12,000 new claims, and on file there are 29,000 open claims, and those are the claims that the IRS this last year and this year are having to go through and see whether or not those claims qualify for an expanded definition of collected proceeds. Here you have two pictures of Bradley Birkenfeld, who is the famous/infamous UBS whistleblower. You have sad Bradley Birkenfeld and happy Bradley Birkenfeld. Sad Bradley Birkenfeld there is in prison for crimes related to the underlying tax fraud on which he blew the whistle. And then immediately upon being released from prison, he bought a big ring and he smokes a lot of cigars now. He was paid $104 million. He is, Caroline tells me, I did not know this. He is seeking a pardon right now from the president, and he also he's alleging that he has even more information to turn over. He also thinks that the $104 million was not enough, and that all the disclosure that took place in offshore accounts he should be given credit for. We'll see how this plays out. The litigation model. So the False Claims Act. The Federal False Claims Act and then State False Claims Acts. This is basically where every ordinary Joe and Jane can bring suit on behalf of the government. These are key tam actions, suing on behalf of the king kind of thing. And you can bring suits against persons or companies that obtain or withhold funds or property through false or fraudulent conduct. You actually don't have to prove you don't have to prove fraudulent conduct. Such conduct is defined as knowing conduct, and that is having either actual knowledge of the false information or acting in deliberate ignorance or reckless disregard of the truth or falsity of that information. The government the way this works in terms of procedure is that the whistleblower will file under seal a complaint with the court, and at the same time file the complaint or turn the complaint over to the agency that's charged with administering the program. And so at the state levels, it's the Attorney General. And then same thing at the federal level, same kind of process is followed. The government then, whatever the agency is, investigates the complaint, and if the government feels like converting it into a civil enforcement action, it does so. If not, it declines the case, and then the government can actually make a motion to the court to prevent the whistleblower from proceeding on his or her own behalf. If the government doesn't do that, or if that motion is defeated, then the whistleblower can proceed as what's called a relator and prosecute the case on behalf of the government. The government, if it declines the case, actually still has a stake in the outcome, and any money that the whistleblower, it's kind of a freebie in some respects. Any money that the whistleblower ends up, or that the action ends up producing, the government has a stake in that collection. The federal FCA, as I said, was enacted in 1863. It has a bar against tax claims, a provision that specifically bars any claim brought under Title 26. There are 28 states and Washington, D.C. that have their own False Claims Act, nearly all of which bar tax claims. Only 6 states don't impose an absolute bar on tax claims. 3 of the states impose partial bars involving actions involving income taxes. And only New York permits claims under its FCA for unpaid or underreported taxes, underpayments of tax, much like Section 7623. This change to New York, or this is a new addition to New York's False Claims Act that is permitting tax claims. The legislature changed the law in 2010 and has the same kind of threshold requirements that Section 7623 has. One of the interesting components of this, and a beneficial one that's in the statute, is that the Attorney General's office in New York has to consult with the tax department first. Some of the complaints from taxpayers about the change in the law was like, hey, the AG's office doesn't know anything about taxes, and if the tax department didn't catch it the first time or maybe took a pass on it, that's something the AG should know about. And so that seems to work pretty well in New York with that change. Losing defendants, this is the same for all False Claims Acts, federal and state. Losing defendants are liable for treble damages. They're also liable for statutory penalties between some amount per claim. That amount changes by state. And when I say per claim, a submission might actually have dozens or hundreds of claims in there, so that starts to add up too. The losing defendant is responsible. There's a fee shifting statute in there, responsible for reasonable costs and attorney's fees. And then relators, that is the person bringing the whistleblower, bringing the action. Successful whistleblowers can receive up to 30% of the proceeds. I will also say, and we'll talk about this in just a second, that the New York statute contains robust anti-retaliation protections. Section 7623 does not contain any anti-retaliation protections. There have been efforts over the years to get those protections put into the statute, primarily from certain senators that are very enthusiastic about, oh boy, here we go again. Enthusiastic about.
After yours.
No, I want everybody to have to endure this. And there have been calls from the IRS itself, from the National Taxpayer Advocate, Government Accountability Office, just a whole slew of folks who are knowledgeable in the area for these protections. I mean, that is for some kind of anti-retaliation protection. Under the New York False Claims Act and other False Claims Acts, there are anti-retaliation protections. The New York one, as I said, is very robust. All of them protect whistleblowers from retaliation for lawful acts that are committed in furtherance of the statute. The New York one goes on to say, and to further define lawful acts in this way, to include obtaining or transmitting documents, blah, 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 even though such an act may violate a contract, employment term, or duty owed to the employer. There's a recent and widely reported case of a tax whistleblower who was a tax lawyer. I'll have something to say about it in just a second. But in that particular case, he brought a claim under the new New York False Claims Act, also made submissions to the IRS and SEC. And the idea here of violating a duty owed to the employer and having that be protected by the statute did not prevent the court in that particular case to say that the whistleblower, the case was thrown out even before the whistleblower lost on not on the substantive merits of the case is a better way of saying this, but rather because the whistleblower was a lawyer and according to the court under the ethical rules in New York could not actually blow the whistle and expect to receive an award because of the ethical obligations in the rules of professional conduct in New York. I've written extensively on this topic. I think the court got it wrong, but there's and the only reason why I really mentioned it here is because it was interesting to see from the last panel when Professor Baker was talking about the legal professional standards and those confidentiality rules and how in the cases that he highlighted anyway, that seems to have been overcome. Confidentiality, quickly, is we have confidentiality both with respect to the whistleblower's identity, that is ensuring that the whistleblower, that the taxpayer isn't tipped off to who the whistleblower is, and the IRS has adopted, as it does in other areas of the law, the IRS has adopted the informant's privilege, which is a longstanding body of law in the United States, to protect the identity and confidentiality of whistleblowers to the fullest extent of the law. It's not foolproof. There's also confidentiality issues with respect to taxpayers' identity, that is the actual sort of the subject of the investigation. And here the concern is twofold. One, that the government might be disclosing information about the taxpayer to the whistleblower, him or herself. And there are a whole bunch of code sections in Section 6103, which is our confidentiality of tax return and taxpayer information section, whereby the IRS can enter into what amount to confidentiality agreements or information sharing agreements with individuals. The problem is that there's no penalty associated, or at least substantive penalty associated with violating those agreements. And so there is, in terms of legislation going forward, there's efforts to actually provide more substantive penalties for violating those agreements. There then is also concern over just through the court's discovery process that the taxpayer's information might become publicly available. Obviously, there's protective orders and other things that a court can do, but nonetheless not foolproof. Finally, in terms of pending legislation, currently the Whistleblower Office just released its annual report, fiscal year 2018, in February. The disclosure of taxpayer information and the anti-retaliation protections are high on the list of legislative efforts. The guidance, right now the Whistleblower Office is working hard on getting new forms out that reflect changes in the law pertaining to this expanded definition of collective proceeds. On the litigation front, we had a really interesting case filed under the False Claims Act of New York. A settlement was reached in December of this last year whereby Sprint, telecommunications firm Sprint, paid New York, settled for $330 million to settle allegations associated with Sprint not collecting state and local taxes. The whistleblower in that case received $63 million. 2013, this is the case I was talking about before. The Vanguard whistleblower alleged the underpayment of taxes over 7 years of $35 billion. That was a transfer pricing issue. New York, he did not appeal the case. He did appeal the case, but he rescinded his appeal in New York, but there are still submissions to the SEC and to the IRS that are pending. Then we have this crazy guy, Michael Diamond, in Illinois, who literally, he's the king of qui tam, is what people call him. He's made a career out of filing literally thousands of qui tam cases. And over the last year or so, the Illinois courts have gotten kind of tired of it, and they are dismissing those cases en masse. And I will turn this over to the rest of the world.
Great. Well, actually, if there's any questions for Dennis, keep your seat. We're going to try and fix the slides to avoid the automatic forward. Any questions? Go ahead.
Yeah, of course. So, a lot of big companies. A lot of big companies prepare large, very complex returns, and there's probably a lot of mistakes on those returns. And you have professionals, accountants who have CPAs and lawyers working in these offices who may discover one of these mistakes. And it sounds like your position is that it would be okay for them to just become a whistleblower on a mistake they discover in their own tax department, for example, rather than try to disclose the mistake to their own company to give the company a chance to fix the mistake. I mean, how do you prevent that kind of corruption in companies? Because the IRS statute, people could become very wealthy instantly by participating in their own corruption in companies. So how do you prevent that kind of behavior in companies and business?
Yeah, it's a great question. I mean, this is a perennial concern about the program, or that the initial sort of reaction is that. There's a couple responses to that. One, certainly not becoming instantly wealthy. It does in fact take 9.32 years to prosecute this. It's not a painless process. The employees who engage in this will tell you that they're blackballed, they're fired, they don't have jobs. I mean, Dannon lost his job. He's been out of a job ever since. Maybe he's a good or a bad example. So the lure of a possible payment, you would be foolish to think that there's any sort of even close to guarantee about it, even though you think you have a nice, tidy case associated with it. And the whistleblower bar is robust and very strong. And if you go to any whistleblower lawyer, the first thing they'll tell you is like, hey, listen, whether it's tax or SEC or False Claims Act, that, hey, listen, this is going to be a long and painful process. I mean, that should be what they're telling their clients. This is not going to be easy, et cetera. In terms of lawyers, I'm not encouraging lawyers to rat out their clients, but in the event that lawyers, I mean, they do have reporting up obligations, as you well know, under all of the rules of the 51 jurisdictions in the United States. That is, you have to report up knowledge of legal violations or violations of the law that might be attributable to the organization, that might cause substantial injury to the organization. So you have to exhaust that reporting up obligation and remonstrating with the client and trying to talk them out of it, et cetera, before you even start to consider whether you can go to law enforcement.
Right, but that point that you just made is not in the statute for the whistleblower.
Oh, well, but
There's no
fair.
requirement to exhaust responsibilities in the statute.
Yeah, no, you're totally right about that. But there are antecedent obligations as a legal professional that govern your behavior in that instance, and so that's why it's not enumerated specifically in the statute. The IRS 7623 is basically agnostic as to whether or not lawyers are legal professionals, tax professionals are providing that information. They treat it differently upon receipt. That is, when they actually get the claim, they treat submissions by legal professionals, and in particular tax professionals, much differently. That is, they're very much concerned about conflicts at that point and tainting the investigation. And so they have a reason in those instances to take a more careful look. Under the SEC whistleblower program, I mean, you have standards of practice that were promulgated that Congress commanded. The Congress commanded the SEC to promulgate in 2002 as a result of Sarbanes-Oxley, whereby you have those reporting up obligations, absolute reporting up obligations, and then if in fact you don't receive a timely or reasonable response, you now are authorized by the SEC to go to the SEC and basically blow the whistle on your client. And in addition to that, the statute, the Sarbanes-Oxley, and then the regulations that have been promulgated thereunder say that this is SEC Rule Part 205, that they preempt any state ethical obligations that you may have or state ethics rules. In addition to that, and then I'll be quiet, in addition to that, the rules of professional conduct over the last 30 years or so have changed considerably with respect to permissive disclosure of client information. And so 32 out of the 51 jurisdictions in this study that I did have disclosure rules that are as permissive as the ABA Rule 1.13, which reflect SEC Rule Part 205, where you have the reporting up obligations, and then if you follow through, it's all about process. You have to cross your T's and dot your I's. Reporting up obligations, and then you have permissive disclosure, assuming that you've followed the rules.
Dennis, have you ever seen a shareholder derivative suit against a corporation for failure to file taxes properly? Sure. No, perhaps.
Yes, those exist.
Yes.
Yeah.
So they're not uncommon?
No, I mean, I would say not.
I would say they're not uncommon,
Yeah.
particularly in these days.
They're not publicized.
You've seen them in the domestic arena. Yeah.
Typically filed under, apart from the whistleblower provisions as such, but rather as a generalized shareholder derivative suit for failure to
They're
properly
filed
file
under
laws?
the civil procedures in the jurisdictions of the federal rules of civil procedures.
Yeah, okay, thank you.
Drita, did you have a comment, question?
Just to follow up to this gentleman's question, very likely, once the IRS or whatever other agency confronts the client, they likely will correct the error. And I just wonder what your thoughts are about how that will impact the amount of the reward.
You mean correcting the error?
No, correcting the error will just give the collected proceeds. But now there's a calculation about what the award should be, what percentage.
Oh, you mean the statutory change in collected proceeds?
Right.
What it's going to do to the amount of the awards?
Not that, the percentage could be anywhere between 15 and 30%.
Right, fair enough. Sorry, so the amount collected
Yeah.
under the expanded. Well, I mean, the amount collected is it is an expansion of what counts as collected proceeds, to the extent that then the application of the percentage. I mean, if you look at the regulation, the application of the percentages, it's not rote. I mean, there's some discretion in there, but it does show like upticks in the award and decreases in the award based on certain behavior. One of which addresses. I'm sorry, what was your name? The gentleman that asked the question.
Alan.
No, I know you, Alan. I'm sorry. What was your name? I'm sorry. Jeff. So Jeff raises the point about sort of profiting off of your bad acts. That's one of the reasons why Birkenfeld's award was lowered. Was there is a part of the statute that says, I mean, it can be reduced all the way to zero, right? So you can't engage in the misconduct and then then turn around and blow the whistle on the misconduct that you engaged in. such that, I mean, you can do that, but you're very likely not going to be getting any awards. And if you look at the whistleblower office's determinations of award and what they do with respect to submissions, it shows different categories for what kicked things out, and then also the kind of things that lowered awards, and you can see that they do that quite often.
There's also no immunity. So if you're a rogue employee engaged in the conduct, committed the conduct, and then ratted themselves out, Department of Justice is not giving immunity to whistleblowers as a general rule. Yeah. Yeah. So, okay. Thank you, Dennis. Okay, I think we fixed the slides, and we're moving on to South Africa. It's like a trip around the world. This is great.
Good morning, ladies and gentlemen. My name is Monre Botha. I'm co-presenting with my colleague, Karika Fritz. As you've heard, we're from South Africa, so next year, our institution, will host you, so hopefully we'll see quite a few in sunny Pretoria. This is what our weather looks like in winter, so this is the coldest it will get, so don't worry too much if it's around the same time, because it is pretty much the coldest it will get. I'm going to look at South African positions, so I'm going to give you a few highlights. We've written a 37-page paper. Obviously, due to time constraints, we cannot obviously present the full paper, so we have done a paper. So I'm going to give you a few highlights and maybe later on a few lowlights, depending on the type of questions that you ask. So I will be bright, brief, and be gone. Okay, so on this slide that I'm presenting, that's why we decided with very, very brief slides, just to discuss you the general regulatory framework in terms of establishing a possible whistleblowing tax program in South Africa. And we're looking at whether a reward program similar to the one in the United States might work in terms of the regulatory framework. Now, our constitution is the starting point in terms of discussing such a framework, because you have to look at the whistleblowers' rights versus the evading taxpayers' rights. It's very important to also look at tax administration, and Karika would specifically look at that perspective. If you look at a constitution, and we have to look at the values, you look at human dignity, transparency, accountability, corporate governance, and that has been taken over into the second act, which was enacted in 2000. So it's quite an old act, and it was recently amended in 2017. And this act specifically looks at criminal conduct or potential criminal conduct in the private and the public spheres. Interesting enough, this piece of legislation was written specifically to protect employees. But now in 2017, they have extended the protection beyond just employees, but it includes now under the wide umbrella also workers. So it means someone that works for someone else who is not an employee, or a person that works for an independent contractor, or a client, or the client of a temporary employment services where you outsource your work to a labor broker. So it expanded the protection also to include those persons. Now, the purpose of this specific act is to look at the protection of whistleblowers, specifically because of the fact that we look at economic stability, which can ultimately cause social damage if whistleblowing measures are not implemented. Now, in terms of this act, we have two types of whistleblowing programs. One is an internal program and one is an external program. But the one is linked to the other. So the act clearly provides that an employee or worker must first run through the internal program and exhaust the internal program. And if nothing happened, then only the employee or worker can then blow the whistle to one of the external parties. Now, there's a list of persons internally that a person can blow the whistle. For example, a legal advisor, the employer, a member of cabinet, executive of the council of province or state. If that doesn't happen or it fails, then you can blow the whistle externally to a public protector. We have a public protector in place, the Auditor General, and also the media. The courts have identified that the media is a party that the whistle can blow. We've had a few cases where there was occupational detriment suffered because the employees blew the whistle to external parties, including the media, and the courts were very harsh in terms of the behavior. So that has been identified as one of the channels, but you have to first exhaust the internal programs. If we look at the third act, the Labor Relations Act, now this is a workplace piece of legislation. it specifically now also extends protection in terms of the recent amendments to workers. But it is not as expensive as the protection in terms of the Protected Disclosure Act. But what's interesting about this act, it provides the remedies for occupational detriments. Now, there are two types of occupational detriments. One short of dismissal, which we refer to as an unfair labor practice, where you're suspended or benefits are withheld or a disciplinary action is initiated because you blew the whistle. Then it's an unfair labor practice because you're not dismissed or your services are not terminated. The second one is an automatically unfair dismissal. And this is the list of dismissals which are prohibited. So there cannot be a fair reason for dismissal. So the sanction is also quite harsh. But now, interesting with the recent amendments, the employee, for example, can also now request an inquiry to be held if something happens to by the employee. If the employer initiates some form of sanction that is linked to his conduct capacity, he can also request that such an inquiry can be held within 21 days and also require the employer to provide reasons and the outcome of that. So it's an extension of the existing framework. Any other appropriate relief? And then the Act also now makes provision for joint and several liability between the employer and the client. So it's something new that is also expanded in terms of liability, compensation, 12 months or maximum of 24 months. Damages can be awarded, patrimonial and non-patrimonial damage, for example, if your reputation is damaged because of the fact that you were mistreated by the employer and it's publicized, you can also now claim for the impairment of your dignity, etc., etc. Other steps to remedy the situation, and then lastly, reinstatement. Lastly, we'll see our Companies Act also now contains a whistleblowing provision, which is in addition to the one pertained in the Protected Disclosures Act. And here you find that a shareholder, a director, company secretary, a registered trade union, a supplier of goods and services, and the employees of a supplier of goods and services are also now protected in terms of blowing the whistle. So if you supply and you render services and you stumble upon irregularities or criminal conduct, you have an obligation to blow the whistle and you will be protected by the Companies Act, which then is linked to the Protected Disclosures Act. The parties where you can blow the whistle to a prescribed officer of a company, a director, a legal advisor, company's intellectual property commission, the stock exchange. So there's quite a vast list of parties who you can blow the whistle to. Lastly, but not on the slides, there are two additional pieces of legislation. We also have a Competition Act, and the Competition Act also provides for a whistleblowing program where a person or parties who are part of a cartel can blow the whistle in terms of the corporate leniency program. So it's the fastest fingers first. So if you're guilty of cartel behavior, you fix bread prices or whatever prices, and you run to the Competition Commission and say, look here, this happened in this industry. I want some form of protection for blowing the whistle. You can now be protected. You will get a lesser sentence. You will still have to pay fines. You might end up in jail, but it will not be as harsh as it would have been if you didn't blow the whistle first. And then lastly, we also have an act that deals with Prevention and Combating of Corrupt Activities Act. And this specific act extends some obligation on a person holding a legal authority or a position of authority if he or she stumbles upon some form of corrupt activity, including criminal behavior. They have a responsibility based on the authority that they receive or the position that they're in to blow the whistle. I'm handing over to my colleague Karika. I just want to say the guy received $104 million. If he converts that into South African rands, he would be a billionaire, 1.66 billion rand. He can buy himself a nice little wine farm or a nice oceanfront house in Cape Town. Cape Town is really nice, so yeah.
Yes, in South Africa. Okay, good morning. I think from the discussion of Monterey, it's clear that we have a legislative framework for whistleblowing, but you will note that there's no specific framework for tax. So that is a bit of something that we want to expand on and that we've worked on our paper to say, if we expand this specifically to tax, can we use this framework for tax purposes? And for purposes of my discussion, I want to focus on two aspects. And the first one will take most of my restricted time. looking at what about the taxpayer and his rights to get access to the information, to maybe get an idea of who is the whistleblower and so forth. And then lastly, I want to mention a few things that we think if we were to introduce a specific legislative framework relating to tax whistleblowing, whether it would be possible to have a reward associated to that. So focusing on the first component, I think it is important to note that for a tax whistleblowing program, it's extremely important that the whistleblower knows that their identity will be kept secret. So that is something that is extremely important, but then we need to balance this with the rights of the taxpayer. And specifically in this context in South Africa, there's two rights that a taxpayer might want to rely on in order to get information regarding the information that was blown to the South African Revenue Service. And the first one is the Promotion of Access to Information Act. So the Promotion of Access to Information Act deals with this notion that information that the state has about the taxpayer should be available to the taxpayer so that he knows exactly what they are dealing with. And in South Africa, this is a constitutionally protected right, and we have legislation specifically giving effect to this right. So we have the Promotion of Access to Information, or shortly we refer to it as PAIA, where they specifically indicated when can a person, and for our purposes the taxpayer, request this access to information. So basically in terms of PAIA, there's two requirements. Firstly, the taxpayer would need to comply with the procedures set out, and then it must not be one of the refusal grounds. So in general, you have the right to access to information unless it's a refusal ground. And there's three important refusal grounds for us to consider with a specific focus on a tax whistleblower. The first one is that disclosure of information is refused when it relates to the personal information of another person. So in this instance, on this ground, a taxpayer would not be able to get the information pertaining to the identity of the whistleblower because it specifically relates to the personal information. So this is the general rule. If it's personal information of another person, you cannot obtain this information unless not disclosing it would be seen as unreasonable. So here we submit that it is reasonable to not disclose this information because the whistleblower has an expectation of privacy, which means he has a right to privacy and confidentiality. So therefore, refusing to grant this information would be seen as reasonable. The second refusal ground is when it's information used by the Revenue Authority for purposes of enforcing collection of revenue. So this seems like it fits really into what we're dealing with here. What is important, if we look at the secrecy provisions in our tax administration legislation, which is the Tax Administration Act, it is clear that the secrecy provisions cannot be used against a taxpayer. A taxpayer has the right to his own information. So you will never be able to say, well, we're refusing you to know exactly what is the basis for an additional assessment and so forth, because it is used in the enforcement of collection of revenue. So obviously the taxpayer would have access to that information in terms of PAIA. However, it is submitted that the identity of the whistleblower would not form part of these secrecy provisions or the exception when the taxpayer is allowed to know the information. So therefore, the whistleblower's information, his identity, will still remain intact because this refusal ground would mean that the taxpayer cannot access the specific information regarding the identity of the whistleblower. Then the last specific ground that relates to our discussion, the last refusal ground, when a taxpayer would not be able to access the information that is requested, is when this information is confidential information between a public body, such as the South African Revenue Service, and a third party, in our instance, the whistleblower. So the one part is when there's a specific agreement for confidentiality, but even if there's not an agreement for confidentiality, if it is reasonably expected that disclosing this information that was given in confidence by a third party would prejudice future supply of similar information, and that specific information is in the public interest, then you would not be able to disclose that specific information. The refusal ground will apply. So if we look at this in context of our discussion, generally, if a a whistleblower's identity is revealed, he is not going to provide information at a later instance because there is a fear of retaliation. Also, that would have an effect on other potential whistleblowers as they know that they are not going to be able to remain anonymous. So that is extremely important to remember. So looking at the refusal grounds, mostly we can say that the identity of the whistleblower will be protected. What is important, however, is in all three of these instances of the refusal ground, we have what we call the public interest override. So the public interest override would apply when this information specifically pertains to or relates to contravention of a crime or contravention of laws or something that constitutes a crime. So in our instance, the taxpayer would like to have this information as a specific or information regarding the whistleblowing as it specifically relates to tax evasion, which constitutes a crime in South Africa, and I assume almost everywhere. So then we need to consider the public interest override in this instance. So here we need to weigh the interest of the taxpayer in accessing this information against, of course, the reason why we have this specific refusal grant. And that would need to be done on a case-to-case basis, specifically pertaining to the situation, to evaluate exactly should the refusal grant remain or is it in the public interest to provide the information to the taxpayer. And here I think it is important to note that in general, the information that the taxpayer might want to access relates to his tax affairs. But what could be tricky is if that information would indirectly reveal the identity of the whistleblower. So that is something that needs to be considered before releasing this information. So that is the first right that could have an impact, was the right to access to information. Then the second one is, in South Africa, we have a constitutional right that protects gives us the right to administrative action that is lawful, reasonable, and procedurally fair. And specifically in the Constitution, it states that when there's administrative action, reasons needs to be supplied for this. And again, we have legislation specifically giving effect to this right and making sure that we understand how to deal with this right. And this is the Just Administrative Action Act, the Promotion of Just Administration Action Act. And when we apply to this scenario, usually the administrative action that would apply is SARS would issue an additional assessment after receiving this information pertaining to the possible tax evasion. And then, of course, the taxpayer has the right to request reasons. But once again, looking at case law, what has been established is looking at reasons or requesting reasons is not giving full details. The reasons or the basis for the reasons should simply put a taxpayer in the position to say, even though I do not agree with your assessment or your administrative action, I'm able to understand the basis of it, and now I know how to challenge it. So it's just to inform him so that he can proceed. So again, here, looking at the promotion of administrative justice and the right to administrative justice, it is clear that the identity of the taxpayer of the whistleblower should remain intact, because that is not part of requesting reasons. That would go beyond the ambit of requesting reasons. And then just the last part I wanted to, we do not have any pending legislation or anything in relation to tax whistleblowing, but we do find the thing of having an incentive for whistleblowing, we do find it attractive. As it's extremely important in South Africa at the moment, we have huge tax deficit targets because we had a few issues at our South African Revenue Service. So we need to have some kind of plan to make sure that we recoup or we get taxes that's legitimately owed to the government. So whilst it is important to consider maybe a monetary incentive, there's certain things that should apply and things that we have identified that we think is important in the South African context. Firstly, we need to make sure that whistleblowers are aware of the fact that their identity will remain confidential, and I think we do have the legal framework to ensure that. Of course, the identity of the whistleblower will be known to SARS in order for them to make the payment, and then for them to make sure that it's not just simply malicious statements, it's an ex-wife all of a sudden ratting out her husband.
Also, it's important that the information that is provided must be undiscovered information and would have not been able to be discovered in another way. Otherwise, if it's something that's already there or they're already busy with the audit and would have been uncovered, it is not really blowing the whistle in that regard. Then, of course, it needs to be, the reward needs to be linked to the revenue collected. And then ultimately, I think it's extremely important that whenever we deal with these things, our overall consideration in South Africa should be the public interest. We've seen this throughout, looking at the general framework, looking at how we deal with PAIA, that the public interest should be the paramount thing to consider when we deal with this aspect. Thank you.
Thank you. I first want to echo Dennis in thanking Nina for everything she's done, among which is showing not just U.S. Academics and professionals, but also the rest of the world what can be done in this area of protecting taxpayer rights. So I feel very honored also to be on this particular panel. My perception is that the U.S. is sort of the center of expertise of tax whistleblowing. You have something called a whistleblower bar. I don't know if you can find that in other countries. And so we're definitely not whistleblower specialists. So what I'm presenting is joint work with Sherry Wang, who's sitting in the audience. And we're just starting to write the paper, doing the research. So I didn't ask Sherry to prepare a presentation to come up to, because our work is just starting.
Thank you.
Yeah, so one idea we had in looking at the presentations that other panel members prepared and also looking at some of the paper is the US has a lot of expertise in this area, but that's conditioned on having this regime that Dennis talked about, which gives high rewards to in very high value cases. And one question we have for basically everyone in the audience is whether this kind of regime is relatively unique, and we may not observe that very often in other parts of the world. And the question then is, what are the pros and cons to introducing a regime of this kind? And so high value tax evasion being exposed by high stake whistleblower reports has a recent example in China. And so this is the Chinese actress Fan Bingbing. She's very famous. This is her in the Hollywood movie X-Men. I don't know quite that about. I spend my spare time reading about whistleblowers. So anyway, she's very famous. And here's another person who's very famous in China. His name is Cui Yongyuan. He has the same last name as I. He's a television personality, and so people, my generation, grew up with him, watching his shows. So these are two celebrities. One is the tax cheat, the other is the whistleblower. Can you guess who is who?
Oh, no, she's a whistleblower.
Yeah, so he turned out to be the tax cheat. So she turned out to be the tax evader. She was caught and had to pay tax and penalties and late interest for 800 million yuan last year. So that's a very high stake case. Many people are caught along with her, and this is all thanks to Yongyuan, who was just disgruntled with her clique. So this was a big phenomenon in China. Many people around the world followed this event. And he wrote a blog post. He said, some friends told me that I could go actually get a whistleblower award, and that's capped at 100,000 yuan. To him, it's not a lot of money. To a lot of people in China, it's a lot of money. But he actually complained about being treated badly by tax agencies, being harassed during this process. And so we started thinking about this, how his experience could have been improved by a regime that the U.S. has. And so I'll show you what research we have done. So 20 years ago, back in 1998, unbeknownst to the rest of the world, and maybe unbeknownst even to people in China, China was sort of the epicenter of tax whistleblowing. That year, there were over 220,000 reports of tax evasions by whistleblowers. There were close to 6,000 whistleblower offices across China. They employed 15,000 staff members. With that many staff members, you don't need a whistleblower bar. They handle all the claims. Payout was 64 million Chinese yuan, and all of these were the peak. In terms of revenue collection, 1998 was not the highest year, but it's one of the higher years. It's 2.2 billion in revenue. And so the question, so everything has been downhill since then. Nowadays, the annual number of reports is about 30,000. And the number of investigated cases also diminished faster, so the proportion of reports that led to investigations is lower, and the number of rewarded cases dropped from about 20% down to the low single digits to 3 or 4%. And so the question is, what explained that large decline? There's a very clear answer. The model of this very whistleblowing at the mass level is something that fit this description. I take this from U.S. history, and so back in the 19th century, people in the U.S. talked about the idea of making every citizen a deputy tax collector, spying on neighbors, and looking out for the government's interests. And this is in connection with the publication of tax returns. And so another way in which you can implement this kind of tax collection mechanism is by having very low threshold tax whistleblowing. And this is what China implemented in 1998. And that was also when the government tried to put in a modern audit system and called tax inspections. And whistleblowing was supposed to be a major primary way in which audits can be initiated. So this mass mobilization system had a history going before the 1990s. In our research, we trace it back to at least 1961. It was mostly run at the subnational level before 1998 due to fiscal decentralization. And it's part of a system called letters and visits where disgruntled citizens can go to the government and complain about everything. And so if you tax whistleblow on somebody, you can also express your other discontent. And so this system, this traditional regime began to phase out, and a new idea, which is to having tax whistleblowing feeding the audit system, began to be built in 1997. And you have some legislation. This is the basic statutory framework. There's a general statement about allowing whistleblowing, citizens have the right, and there's duty of confidentiality towards whistleblowers, and there's a possibility of whistleblower rewards. Whistleblower rewards were given ever since the 1960s and 1970s, and this was really codified in 2007. And then there's a set of procedures going back to 1998 about how whistleblower claims could be processed. So in studying all these as lawyers, we try to compare these individual features with the United States, but the background of a different motivation for whistleblowing, I thought it was important to lay out first. So let's look at some of the features of the statutory regime. The scope of tax whistleblowing solicited is very broad. It could be any kind of violation of tax law with no monetary threshold. There's a lot of emphasis on forging invoices, engaging in tax fraud by creating fake tax invoices. The handling of whistleblower claims is very decentralized. All bureaus of tax inspection at the city, provincial, and national levels holds a tax whistleblower center. back in 1988, when there were 6,000 whistleblower centers, that was when the centers operated at the county level. However, whistleblower centers, unlike the whistleblower office at the IRS, is merely clerical. It doesn't do anything. It takes in whistleblower reports, it sends it to the inspection bureau. The inspection bureau carries out the entire investigation and decides how much information to give to the whistleblower, as well as how much reward is given. So the whistleblower office is merely clerical. And because of that, there's actually a strong shift in moving that function into taxpayer services as opposed to having a separate office. Okay. So the rewards are stingy. So we have a schedule here. You can see the maximum reward is 1%, and that's in the 1 to 5 million tax liability range. For at the top, when it's over 100 million, the reward is 0.1%. We did a study using the data that we have. The average reward over the years is 0.7%, and so it lies somewhere in that lower range. That also tells you how much is the reported amount. Okay, here's whistleblower protection. Whistleblower claims are handled by decentralized tax agencies. Tax agency personnel is heavily involved in recording whistleblowers. Usually there's no lawyer representation. That makes protection of any kind of rights actually hard to do. There's a wide range of reasons for denying rewards. So you cannot get a reward if your report is anonymous. You have to disclose your identity from the outset in order to get a reward later on. Illegally obtained evidence leads to the denial of rewards. Information obtained from government agencies disqualifies you from rewards. The decision about rewards is not justiciable. This is not surprising. I think it's the case in elsewhere as well. And there's very little protection against retaliation, and that will not be under tax law anyway. It will be under employment law. Okay. So confidentiality figures in a number of ways. Non-anonymous whistleblowing is encouraged. It's required for obtaining a reward for written confirmation of the report. So if you make a phone call and say that someone did this, you won't even get a confirmation that a report has been made. And also, if you want to obtain information about the conduct of the investigation, you have to disclose your identity from the beginning. Again, it's not even contemplated that lawyers will be involved and the lawyers can take the information for the whistleblowers. Notification of whistleblower of status of results of investigation can be given only after the end of the investigation. Disclosure of investigation needs to be limited to results related to leads provided by the whistleblower. So from these provisions, you can see that people have thought about the system for a bit. So we don't know how these things operate on the ground so well. But we can tell that in the context of decentralized processing of claims, protection of whistleblower identity would have been hard anyway. And so some of the provisions that started in the 1990s that we see today would say when a whistleblower claim is made and investigated, any kind of personnel who may have a conflict of interest must recuse themselves. So if you think about in what circumstances would the person examining a whistleblower claim actually have a conflict of interest, why would someone in the tax agency have a conflict of interest? This is in the context of very local tax administration where the people in the tax bureau may know the taxpayer, may be the people regularly auditing the taxpayer, and the whistleblower may be coming forward to show that the tax agency didn't do their job. So that's one example, and so you normally wouldn't see this kind of provision, but this has been a part of the law. Another one is to say that if taxpayer service centers, if they're taking whistleblower claims, you need to create a separate office for the whistleblowers to meet. Otherwise, you show up at the tax agency, anyone can see you, snitching on taxpayers. So media exposure of tax cheats are is very rare, but the recent publicity of Cui Yongyuan's whistleblowing has received some media support. There is a recent discussion of revising the 2011 SAT regulations, and which in turn was a revision of the 1998 regulation. But there's not a huge amount of momentum to change, and so we can't identify major policy changes. So the impression is that the whistleblowers regime in China is fairly stable, dealing with these low threshold claims. But when it comes to handling the high stake claims that I illustrated at the beginning, we don't have a system for dealing with that. Thank you.
So we're going to move to Sweden. Passports out.
So thank you, Nina, for everything. We are so satisfied that there are lots of persons left here after that reception and dinner yesterday. My name is Ylva Larsson, and I brought my best professor, Eleanor, with me, so I'm very safe here. Because I've tried to get her here lots of times, because I have been attending those conferences, not the first one, but all the others. But you have not, and I've tried a lot to get you here. And now we're both here. We do a lot of things together, don't we? I am a practitioner. I'm an academic now, but I am also a practitioner, and I used to work for many years inside the tax administration. So I give you something about the inside of the tax administration in Sweden. I give you the word.
Yeah. So I'm Elna Kristoffersson. I defended my doctoral thesis in 2001 and became full professor at Uppsala University 10 years ago. And then I was the youngest full professor of 3. So I changed universities quite quickly to Örebro University, where there was only you, Ylva, working half-time then, and we built up our own tax environment there instead. Yes, we are going to widen the scope a little bit on whistleblowing because, first of all, we don't have a system with rewards in Sweden, but then we also think that it's important that tax officers and other employees at the tax administration, that they have the possibility to whistleblow. So we're going to look into that issue as well. I mean, if they find cases of bribery or other irregularities at the tax agency. So we're going to look at both those aspects. So, Ylva.
We have two aspects, as you say, the public and the private sector, you might say. But we start from the beginning. Sweden is not a country, it's a small country, very, very far away, and even very north. We discovered when we went here, very north. But anyway, Sweden is a country that has been for a long, long time, since the 16th century with Gustav Vasa. That's when it all started. And 1766, we got our first Freedom of Press Act. And that is constitutional law in Sweden since that. Has not been changed much, and it's 250 years old. That's something. And the right to public access to official documents, that's what it's all about. And in Sweden, everybody's supposed to get into every authority, look into the papers, unless they are, of course, secret. But usually you can, as a person from outside, come into the authorities, even the tax authority, and have a look on the papers. And that's what this is all about. The tax decisions, of course, we have secrecy within the tax administration, but the tax secrecy is about everything that is made before the decisions. The decisions of taxation for everybody is normally open. So the publicists in Sweden, they are very fond of this, and they publish a lot of things, and we are coming to the Swedish envy soon.
Yeah.
And we know what everybody earn. Nina, you should go there and look for it. Referring to what you said before. And 2010, something happened. And that was the kind of a whistleblower act, we could say. This is the history, and that was the kind of the whistleblower act. We are coming to another one soon, but Eleanor, you go on.
With the 2010 one?
Yeah.
Yeah. That is about that, and now we're looking at when tax officers can whistleblow if they find irregularities in the tax agency. And in 2010, we got this provision in our constitution that a public authority may not intervene against a person because he or she has made use of his freedom of press. And that means that a tax officer can report irregularities to the press. Yep.
Which one?
Yes.
We go on with that.
No, yes. All right. But in 2017, then we got our first Swedish Whistleblower Act. So it's quite new legislation, and that covers both the private and the public sector. And according to this act, employees who report can report serious misconduct. And serious misconduct, that is if there is a criminal offense that renders prison in the penalty scale or similar circumstances. So if somebody discovers, if it's somebody at a company or in the tax administration discovers such a misconduct, then they are allowed to whistleblow. And the system that we have is that first you should whistleblow, or first you should report internally. So you could either turn to your employer, and the employer is obliged to have an independent person which you can turn to with issues on misconduct. And if you don't want to turn to your employer, then you can turn to the union. We have very strong unions in the Nordic countries, and almost everybody, or not almost everybody, but most employees are organized within unions. Also, if you work at the university or wherever. So if you don't want to report to your employer, then you can report to the union. And only if the union or the employer doesn't take necessary action, then you're allowed to report externally. And then you can report either to a public authority, but we don't have a separate public authority for whistleblowing. So then, for example, if you were at a company and you discovered that there is a lot of tax evasion or something, then and your first report internally, then you could report to the tax agency. Or you can also turn to the press or to the media and report to the media in case that there is no action taken internally. And there is also a remedy if you impose sanctions on the whistleblower. So then you have to pay damages, and that was actually that was what was new for the public sector when this act came. That if you got sanctions, for example, you got fired or so from your employer, then you had the right to damages. Yes?
Yes. So what is the Swedish tax agency doing then? And this is quite new. Before, you could make a phone call, or you could write a letter to the tax agency. It's a whole tax agency in the all Sweden. You could write or make a phone call, and it was noticed and stored. Now, the tax agency has made a web form where you can say what is wrong and you can report a misconduct. And the thing is that the tax agency says in the web form that if you don't give your name, you really will be, it will be secrecy, everything. But the thing is, when something happens, when an audit starts or something like that, then the part has a right to insight, or the party, I should say, has a right to insight, and probably can imagine who it is coming from. So that is promised secrecy in the web form is not, we haven't seen it yet, but I think that it's not going to rest like that.
All right. So if you have somebody working in a company, somebody from the private sector who reports misconduct to the tax agency, for example, some kind of tax crime, then, as I said, we don't have any rewards, any system with the rewards. It is not promoted by anybody from the tax agency or from any public authority or so to report on anybody. But so then you could ask, well, why should you report? And this has to do with a very deeply rooted Swedish tradition. And as Ylva said, all the tax decisions are they are disclosed to everybody. So everybody can actually just turn to the tax authority and ask, well, I can ask the tax authority how much you earn. It's no problem, and the same. So that is completely open, and that is very important. No, that is very important for our tax-paying morale, I think, because we pay high taxes, and we are willing to pay.
I'm worried that you're giving Drita some ideas here, so let's,
No, we are.
let's not talk. Okay, no,
Yeah,
right? No,
yeah,
yeah. U.S. officials know.
Yeah. No, but we pay high taxes, and we are also willing to pay high taxes if other people pay high taxes.
The neighbor.
The neighbors pay high taxes. And I mean, if we see the neighbor having 3 big cars and a fancy house, and they don't declare any income to the tax agency, that would be something that the neighbor would probably report to the tax agency. Yes.
And confidentiality.
That is mine. Yeah. I should say something also about the right to pass information to the press. And that is a fundamental right in the Freedom of Press Act, and it came there in 1949, so it's quite new compared to our old Freedom of Press Act. And everybody is allowed to pass information anonymously to the press. It is a criminal offense to seek the source of who has passed the information to the press. But you're not allowed, as a tax officer, for example, you're not allowed to pass secret documents to the press. But you can turn to the press and inform them that if you have seen something in a secret act, for example, and tell them about it. And then you will be protected by the source protection. So it is a criminal offense to seek the source. So we have a very strong source protection in Sweden. But on the other hand, I mean, if you as a tax officer would pass secret documents to the press, then that would also be a criminal offense. You're not allowed to do that. Yes?
So, the pending legislation and or guidance, we haven't got very much, but there is a new directive, EU directive, and you know what's about that for EU members. We have to get it into our legislation somehow. The thing is that this says that the source must be protected and must be secret. So Sweden has a problem here. As we are not very fond of the secrecy, we have to probably amend a lot of laws, and perhaps the constitution, we don't know really. And that's what EU makes to all the different legislations in the different countries.
Yeah. But since we already have this new Whistleblowing Act from 2017, we don't have to do so many changes. So, I mean, that is a confidentiality, is an issue. The directive doesn't protect the right to report to the union, but on the other hand, it's a minimum directive, so we think that we can keep that. And I think that the limit for when you're allowed to whistleblow will go down a little bit, because as I mentioned before, that you're only protected by our Whistleblowing Act if there is serious misconduct, and that is if you report on something that could render imprisonment. But I think the level will be a little bit lower, so you can report those other things and be protected by the directive, and it is supposed to enter into force. I'm not sure whether there is only one last step, and that is that the European Parliament has to adopt it, and it might already have done that. It is supposed to enter into force the 1st of July this year, and then the member states will have 2 months to implement the directive. Yeah, I think that was everything for Sweden.
Thank you.
So thank you for that. It really does give new meaning to keeping up with the Joneses in Sweden. So, that's our panel. Any questions before we go? I know we're cutting into your break. No? Okay. Thank you so much for participating. Oh,
Before break, I've got an
okay. Go ahead.
So sorry. Great panel. Quick logistical thing, in the grand scheme of things you've forgotten along the way. So for my Minnesotans in the audience who are hoping to get CPE or CLE credit, there are sign-in sheets on the registration table out there, so you can sign in. For people for other states, my understanding is that the Taxpayer Advocate Service, if you will simply email, if you need a certificate of completion, if you'll email the Taxpayer Rights Conference email, they will send you the certificate of completion that you need. For the Minnesotans, we'll handle it because we're used to that, but our staff has limited capacity for other states. Anyway, if you have any other questions about CLE or CPE, you can ask me or you can ask the ladies out at the registration desk. Thanks so much. Enjoy the break.